Now we're in a strange situation because there was an illicit commingling of assets, and in Texas they got this law that if there has been a commingling of assets and then you can prove your case of fraud, then you can choose from the bag of all of the commingled assets what your recovery is. It's one of the reasons why I think that certain people, when they report fraud, it gets sat on. It gets sat on while other people who have their fraud reports are able to then get put into that pool so that they can take their recovery or whatever they consider to be whatever would be the redress for what happened to them from the pooled assets. So you're waiting for a claim for fraud that you've placed in order to be answered, and somebody else is getting their fraud claim already taken care of. So they're taking your stuff while you're waiting. And it's going on and it's dragging out and it's dragging out. And unfortunately, they don't seem to have a great deal of discretion in terms of defining definitively whose is what to begin with. So even if you get a bunch of stuff and it's been pulled together because it was used in fraud, you shouldn't be able to just arbitrarily assign and decide who you think should get priority to get access to the pooled assets first. So what is left by the time you finalize your claim? What if you had a claim that had national security importance? What if you had a claim that had discussions about or concerned matters that were very important, like evidence in a criminal proceeding? That somebody was trying to commingle with a probate case because they were literally trafficking children as part of Medicaid fraud and Medicare fraud and pension fraud. And the kind of pension fraud that they were involved in involved availing immigrants or accounts connected to immigrants to military assets. Those are very serious charges. How long do you keep somebody waiting? Until they default? Until you refuse to respond to the report of fraud beyond what the legally required timeline is in order for you to be compliant with your surety? That's exactly what they did. What they should have done is they should have taken seriously a request that they provide the following information in order to prepare for an actual plan of estate involving not only the minors but others considered in any sort of familial relations as part of the ongoing negotiations and the ongoing litigation associated with the alleged dissolution of marriage claim. 1. Any past, current, or pending litigation in which the respondent is engaged, including other custody or child support disputes or real estate disputes. 2. List of any judgments submitted against or for respondent, including amounts of awards and schedules of fees and payments, as well as any taxes assessed and paid. 3. Any liens, foreclosures, or mortgages, including any refinancing on mortgages. 4. Any receipts of federal, state, county, or municipal public subsidies. 5. Any real properties qualifying under tax increment financing, including commercial development. 6. Any real properties qualifying under the Texas Economic Development Act. 7. Any real properties qualifying under the Defense Readjustment Act. 8. List of mineral rights holders on all real property. 9. List of any trust in name of respondent or any company for whom respondent serves as a member of the board of directors or a principal. 10. List of any bankruptcies, collections, or other debts. 11. List of any stocks, bonds, or other security instruments in respondent's name or name of any company for whom respondent serves as a member of the board of directors or a principal. 12. List of any outstanding financial obligations from dissolutions of partnerships, incorporations, agreements for payments of alimony or child support. 13. Any record of current, pending, outstanding, or previous security obligation, debt, promissory note, loan, bond, or payment for legal services relating to custody or marriage divorce proceedings. 14. Any record of current, pending, outstanding, or previous security obligation, debt, promissory note, loan, bond, or payment for legal services relating to possessions or agreements concerning possessions of any person, whether corporate or not. 15. List of any inheritances, trust, or receipts of estate awards. 16. List of any assets connected to any trust for which respondent serves as conservator. 17. List of any security obligation, debt, promissory note, loan, bond, or payment performed by respondent in name of or on behalf of child, including any of the aforementioned securities as a performance as conservator of the child's estate. 18. Any estate or account opened in the name of child on behalf of or by the respondent. 19. Any record of taxes paid for any real property, estate, inheritance, or capital gain. 20. Any record of tax credits accepted, including earned income tax credits. 21. Any will or medical or other power of attorney issued for respondent on behalf of respondent, or that assigns respondent powers as personal representative, administrator, trustee, inheritor, or guardian. 22. Any other tangible asset, including as farming or industrial equipment. 23. Any intangible asset, including patents, awards, or titles to intellectual properties. 24. Any paid or pending claims on insurance. 25. Any current or pending obligations for payment of insurance premiums, including caps on coverage and policy classifications. 26. List of any collateral or inventory used as collateral on any current security, obligation, debt, promissory note, loan, bond, or payment. 27. Any open bank, trading, or savings accounts with statements since March of 2007 and including any account opened with petitioner in March of 2007. Full accounting of all transactions concerning sale of property, including amount and payment of any capital gains or property tax. List of any pension or retirement account, including IRAs and their issuers. List of any taxes, including capital gains taxes on any property connected to bank accounts for which petitioner was a co-signatory. 31. Any transfer of titles on any properties connected to bank accounts for which petitioner was a co-signatory. 32. Copies of any current wills. 33. Copies of any appraisals of properties conducted by attorney for any real property in name of respondent or any company for whom client serves as a member of the board of directors or principal, including assessments and valuations on stock options connected to properties with attendant timelines for optimal exercise of option. 34. Fee agreements and billing records of any appraisal or assessments by the attorneys for above. Now, this was submitted as part of a motion on behalf of the woman on August 18th of 2017. That was plenty of time before all of that Harvey stuff happened and before records started getting mysteriously reconsidered. It was also before the changes to the legal codes concerning writs of mandamus for August 24th of 2017. Now, the attorney was appropriately served. This was appropriately entered into the record, but after the hurricane, there was no evidence of it served as such. It had to be included in some other arrangement, didn't it? This is what that woman was owed. You understand? I consider it to be a basic foundation for demonstrating a good faith effort to engage the litigious process when considerations of the welfare of children come up, especially with people that believe they're entitled to go through a costly litigious process with high-profile lawyers that they're willing to accept the kind of billings for that the husband did. And especially when you're addressing a woman that you expect to represent herself pro se with nothing more than an expert witness to work with.